There are several media reports that Alan Weisselberg, the former chief financial officer of the Trump Organization, is currently in a plea deal discussion involving a possible perjury charge or charges. Weisselberg had previously pled guilty to 15 criminal charges relating to tax fraud. As part of the plea deal, he agreed to testify truthfully in a criminal tax fraud trial of two Trump Organization entities, which were, in fact, convicted of 17 tax related crimes by a jury and fined $1.6 million. The fine was the maximum amount that could be imposed for those crimes. A person convicted of them would have been sentenced to prison. A corporation cannot be imprisoned. I am going to get back to the Weisselberg possible plea deal after I provide some more context here. Those tax fraud convictions of the two Trump organizations involve different issues than the criminal indictments of Trump involving 34 counts of falsifying business records that is currently set for a trial on March 25, 2024. So this is likely now to be the first criminal case against Trump to actually be tried before a jury. A detailed chronology of the issues related to this trial can be found at the Just Security website in an article titled, quote, Detailed Chronology in Trump, Hush Money Investigation, end quote. Those criminal charges relate in part to an effort to conceal the $130,000 hush money payment to the porn star Stormy Daniels made shortly before the 2016 election as a payment to Michael Cohen for legal services. Michael Cohen paid Stormy Daniels out of his personal funds paid through a shell corporation that he set up for that purpose called Essential Consultants LLC. That shell company did not pay Daniels directly, but her attorney, with Cohen characterizing the payment as an attorney retainer. Cohen was reimbursed later in separate payments made by Trump and the Trump Organization. Trump signed two of the checks to Cohen, and they are available for viewing on the internet. The indictments also allege that payments were made to the Playboy centerfold model Karen McDougal and a doorman to prevent scandals from circulating during the last stages of the 2016 campaign period. The charges do not apparently involve Trump or the Trump Organization deducting the hush money payments as business expenses that reduce their state and city tax obligations. I've not seen any indication that that is a subject matter of the case. Instead, and this is a problem for the prosecution, a conviction requires proof beyond a reasonable doubt that the falsified business records were done to commit or conceal another crime, which is necessary to obtain a felony criminal conviction. That kind of proof is not necessary for a misdemeanor charge. The other crime that the DA may be attempting to establish is an attempt to violate state and federal election laws. The case may fail there, not on the issue of whether the business records were falsified. Michael Cohen is the chief prosecution witness in the criminal case, which is an obvious problem for the prosecution. Trump may also be able to convince the jury that the reason for the hush money payments was to keep his wife from knowing about the allegations that he had extramarital affairs with a porn star and a Playboy centerfold model. And he denies having those affairs. I personally view the payments as hush money to prevent more damaging information from being released shortly before the election, when Trump was already reeling from the Access Hollywood tape that was released on October 7, 2016. The hush money was paid to Daniels' lawyer on October 27th. Now back to Weisselberg's possible plea deal for committing or allegedly committing perjury. None of the articles discussing that issue indicate that Weisselberg would settle that charge by agreeing to testify truthfully in the upcoming Trump criminal trial. Cohen places him in the mix of the discussions that he had with Trump about the hush money payments and otherwise orchestrating the reimbursement of Cohen. His testimony could bolster Cohen's testimony if he was willing to give it. However, it is my understanding that Weisselberg is still refusing to cooperate in this matter and does not appear willing to cooperate as part of a plea deal. As to the alleged perjury charge, an article published to date do not specify what that is about. I did previously discuss in my blog a publicly made claim by a senior editor of Forbes magazine who disputed Weisselberg's sworn testimony that he never focused on calculating the square footage of Trump's three-story penthouse, whose square footage was nearly 3 times greater than the actual square footage, and that increased the value of the penthouse in Trump's financial disclosures to banks and other institutions. The Forbes editor made this assertion, quote, Weisselberg absolutely thought about Trump's apartment and played a key role in trying to convince Forbes over the course of several years that it was worth more than it really was, end of quote. He then added that their discussions continued for years, and the ex-CFO was very hands-on in coming up with the evaluation. Quote, and then he said, quote, it defies all logic to think that he truly believes what he is now saying in court. The belief is that the DA is not trying to turn Weisselberg against Trump in the upcoming criminal trial, but is sending a warning to other witnesses about lying in that trial.